This is a presentation about workplace antitrust liability. I'm an employment lawyer, and I'm going to be talking about where companies get into trouble with antitrust issues in the workplace and the rights that employees have, and also the government has with respect to antitrust claims against employers due to workplace issues. So I want to just start out on a very high level with how antitrust law applies in the employment world. Typically, people think of antitrust issues as relating to products, but labor is typically deemed a product. And so, for example, it's covered by the antitrust laws. And the idea of the antitrust laws is we want to make things competitive. We want to allow for the best price out there. And so the real focus of it with employment issues is we want employees to be able to get the highest wages and the best deal that they can at work. And we want them to be able to go from job to job without having restrictions. We want them to be recruited from competitors, because ultimately the theory behind antitrust law is that if people are competing for employees, that will raise the wages that the employees get. So this is important for employers to know because they are being sued quite a bit now, and specifically they're being sued in three different areas. From regulatory agencies. So for instance, the federal government, the Department of Justice, is going after employers for antitrust liability. There's also state attorney generals that are filing claims against businesses under state antitrust laws. And then finally, there's class action lawsuits where the employees themselves are looking to seek and recover damages for antitrust claims. And so that can be very expensive from an employer perspective. So let's hop into what the relevant laws are. The main law that we're going to deal with is the Sherman Antitrust Act. And that's a federal law that's been on the books for a long time. And it's more recently, though, been applied in the workplace. So, in a nutshell, you can't have agreements for strict trade or competition. But on top of that, not only are there other federal laws that are relevant here, but you also have many states have their own separate antitrust laws. For instance, I practice in Chicago, Illinois, and we have an Illinois Antitrust Act that's very similar to the federal antitrust laws. But it has some unique differences that are very significant. And so if you're a business, you need to comply not only with the federal antitrust laws, but whatever antitrust laws apply in the state where you operate. And it might be you operate in multiple states, so you need to be familiar with those laws in all the states that you operate. So what does that mean for hiring employees? The big thing that I want to drive home is that no-poach agreements are illegal. It's interesting, poaching often has a negative connotation to it. It sounds bad, like if you're poaching something from somebody. But that's actually exactly what the antitrust laws want to see happen. They want to see people poaching each other's employees. And the reason being that if you're hiring away other people, you're probably paying them more to leave their old employer. Typically people leave for a reason, and often that reason is more money. So if you're out there recruiting and soliciting other companies' employees, you're probably offering them more money, and that's what the antitrust laws are designed to do. So you can't have agreements with competitors that, for instance, you agree not to compete by saying, hey, look, if you don't hire my employees, I won't hire your employees. That's going to be the type of agreement that is probably going to be problematic. Some people call it stealing employees, recruiting them, poaching them, whatever term, it really doesn't matter. You just can't have agreements like that. And you can understand why a business would want to do that. They're training an employee, they're putting a lot of time into that employee, and the last thing you want to do is to have them taken by that competitor that you hate. But that's what the laws allow, and the justification from an antitrust perspective would be, if you don't want to have them leave, then pay them more. It's important to remember that even informal agreements can be illegal. So, a lot of people think of an agreement as like a written down, formalized agreement that a lawyer writes up. That's usually not where there is liability in the antitrust world. Verbal agreements are potentially problematic. Handshake deals, those can be a violation. A text message, an email, that can all be proof that can lead to antitrust liability. So, you say to one of your competitors, you run into them on the street and you say, hey, what the hell? Why did you recruit all my people last week? You hired away 10 of my people. And they say, well, you're at the grocery store, and he says back to you, well, I'll tell you what, I'll leave your folks alone if you agree to leave my folks alone. Deal. Okay, that can be a problem right there. Seems informal. Nothing in writing, not a trace of evidence, except when that person, your competitor, is put under oath and testifies against you, a few years down the road when there is liability. It's pretty. You might think, oh, it's my friend, the competitor, or it's this. They're not going to tell on me because I'm not going to tell on them. But liability comes in a lot of different ways. You might tell one of your subordinate employees, like, hey, don't go and poach this guy's people. They're not gonna hire away any of ours. And then that person you told it to becomes disgruntled and reports you to the state attorney general or the Department of Justice, and then you find yourself on the wrong side of a lawsuit. So very, very important not to enter into agreements like that, even if you think they're informal. It's not a real agreement. So as an example here of some liability, there's a $435 million settlement paid out. A number of companies involved, household names, Adobe, Apple, Google, companies like that. And there was an allegation that they had an agreement not to poach each other's employees. They wouldn't cold call them to have them go to work. Cold call being, hey, Mr. Smith, how happy are you at your current job at Apple? Do you want to come over and work with us? Calling them out of the blue, so to speak. Even though that was maybe a small piece of the recruiting effort, you just can't have an agreement that you won't, do something like that. And the logic behind that is if you are recruiting and you are cold calling them, then you're probably calling them to make more money or give them better benefits at a new job. So the exposure in these cases can be very substantial. Price fixing. So in the context of antitrust within the workplace, this often relates to wages, but it can be other things. It can be things like benefits. So you can't go to your competitor and say, look, these prices are getting out of hand. Inflation's on the rise. Let's all agree we're not going to pay our hourly workers over $35 an hour. Or I'll agree not to go over 35 if you agree not to go over 35. Now, that can be good for the companies because that means that they're going to keep the wages low. But then the problem with that is, from an antitrust economic perspective, if one company raises their rates or their pay to $40 per hour, they're going to get more people to come over and work for them, which is going to make other people have to raise up to $40 an hour to match. And so again, the idea being that competition is good for society, that's the theory behind antitrust law. So So you can't agree to keep wages low. You also have to be careful about the information you're sharing. Even if you're not formally saying, hey, we're going to all agree to keep wages low. If you're sharing what your wages are, and particularly if you don't have public information out there about what your wages are, but you're sharing that and everybody's kind of has an understanding, okay, I see they're paying 40 an hour, so we have no reason to go over 40 an hour, why should we do that? The Department of Justice sued the Utah Society for Healthcare Human Resources Administration for conspiring to exchange non-public information about wage information about registered nurses. And the idea was that the exchange of information that they had caused them to match each other's wages, and it kept the wages artificially low. So just sharing of information can be problematic. Aligning pay rates with competitors to avoid competition. That's your classic example of wage fixing. The Department of Justice filed an action in Arizona against the Hospital and Healthcare Association that had a uniform bill rate schedule that they would pay out for nurses. And again, if you're talking about a uniform rate that you're paying out along with all your competitors, that's going to raise antitrust concerns. So that's something that employers need to be careful about, and that if an employee is aware about, they should consider consulting with legal counsel about, why is it that I'm subject to this agreed upon wage schedule with all the folks in this industry that I work in? I want to be able to go somewhere and make more money. So the Department of Justice has put out some information about red flags for antitrust employment practices. And this slide comes right out of the information that it puts out. So, we've talked about agreeing to keep compensation at a set level. That's a big red flag. Agreeing not to hire or solicit another company's employees. Of course, a big flag. Benefits, agreeing to keep benefits the same. Again, benefits may not be like cash, but benefits are a big part of why people work. And if you're agreeing to limit benefits, then that can raise antitrust implications. And then, the other ones are pretty common sense, but even like saying, hey, we're not going to aggressively go after each other's employees, that can raise problems. Sharing of information we talked about. That can often come up at trade association meetings. You think about a trade association meeting, you're there with your competitors. What are you talking about there? Like, what kind of issues are you getting into? If you're sharing confidential information about wages or other terms of employment, where everybody can say, well, everybody's keeping their wages pretty uniform. Let's do the same. That can potentially raise some concerns. And then even social events. Maybe you're at a Christmas party for you have a common client with some of your competitors, and you're there and you've had a couple of drinks and you're chatting and you share some information with one of your competitors. That can be a problem down the road, particularly if it comes out in a deposition or something like that. So if employees are aware of these types of violations, there's a number of agencies, the Federal Trade Commission, the Department of Justice, they have their own antitrust division. Employees can report internally and try to avoid reporting to the government if they want to give their employer a chance to fix the problem. Many state agencies, like Illinois, has its own workplace rights bureau that employees can go to. And employees can go to a private lawyer and say, I want you to investigate this. Tell me if it's worth making a report to. Do I have a claim? Are they doing anything illegal?